Right, morning everybody. That's me. Moore, Taylor Emmet. I'm partner in our corporate and commercial department, and I basically sort of day job helping businesses be sold and helping people buy businesses. So I'm going to sort of just go through a fairly swift canter of the whole legal process for whether you're doing a trade sale, an MBO or an EOT. So first off, things to think about before, right at the very beginning of the process. For all three types of the deal that we're looking at, there may be some form of pre-sale reorganisation required. For example, we did a deal last year where the company being sold, which lawyers call Target, the Target company, the Target had an American subsidiary. Shareholders didn't think that would be attractive to a buyer, so that was hived off before there was the process started in terms of the sale. Very important thing, if you're selling a business, you need to be confident that the party that's coming in to buy the shares has got the cash. So you need to have a conversation very early on in the process to basically find out where the money's coming from, how it's going to get paid. You certainly don't want to instruct professional advisors what can be a very expensive process just to find out further down the line that basically the buyer's not good for the money. Something which is becoming, it's a bit niche, but it's becoming more sort of prevalent now in deals that we see, is this National Security and Investment Act issue. Basically, this is newish legislation that came in a year or two ago where the government have said that if a business is within one of various what they determine to be high-risk sectors, things like obvious ones, nuclear, defence, but also things like transport, energy, artificial intelligence, then there needs to be a notification to the Secretary of State before the process starts to basically get consent from the Secretary of State the deal can go ahead. The legislation makes it more of a buyer problem rather than a seller problem, in the sense that if the buyer doesn't get consent when they ought to have done, there can be a massive fine. There might even be a criminal process started. But it's becoming more common now that buyers are including within the warranties they're expecting the sellers to give that there are no issues arising from this National Security Investment Act. So it's important from you as seller's perspective to have a conversation with the buyer at a very early stage and collaborate and decide whether there needs to be a notification to Secretary of State, and if so, get it done at a very early stage, because obviously, again, if you do need to get that consent, Secretary of State says no, you don't want to have wasted a whole time and money having gone a long way down the road. Again, right at the very beginning of the process, one of the most important things you need to do in all three types of deals is to get a confidentiality agreement signed, or otherwise some people call it NDA. So you don't want to be providing any information about your business to anybody until you've got a document signed where they agree that they will keep that information confidential and not use it for their own benefit. Not every deal includes heads of terms, although it is very common, and it does apply certainly for all three types of the process we're looking at this morning. Heads of terms in the main are non-legally binding, so by signing heads of terms you're not actually sort of selling the business there and then. Heads of terms are very useful because there were some of the commercial points, like dealing with how the purchase price is going to get paid, how much, things like that can get sorted out at a very early stage. It saves time in the long run. Heads of terms might include an exclusivity clause, which basically is something for the benefit of the buyer. So you as sellers would agree not to talk to anybody else whilst you're engaged with the particular buyer that you started talking to. If you don't have heads of terms, it's normally the case that a buyer would expect you to sign an exclusivity agreement separately, because they're not going to want to spend a whole load of money and spend a whole load of time particularly doing the due diligence, if you might be talking to other people at the same time. Okay, so once you've got through the preliminaries, the next stage is due diligence. If it's a trade sale, then normally it's the case that your potential buyer will know very little about your business. So the extent, or the due diligence will be very extensive, and it will cover every aspect of the business, financial, legal, accounting, every single thing. And it's a long process. If we're acting for sellers, we will set up a virtual data room, and all the information which is requested will be uploaded into there, and we can control how it's actually given to the buyer. It's normally the case that you get very long due diligence questionnaires, and on the back of that you'll get lots of supplemental questions. So I know it's already been said, previous speakers, that there is some frustration that can come out when it comes to DD, and that's certainly the case. DD is also, there will be slightly less due diligence for an MBO, because the buying team will already have, or ought to have, a detailed knowledge of the business they're buying. In an EOT, yes, there may be some, well, possibly not any at all, particularly if the buyer will include, or that the seller is actually going to remain part of a trustee, or part of the original trustee company that's actually buying the shares. Once the DD's done, then we get into the the main sort of legal documentation proper, and the main document is an SPA, a share purchase agreement. And in a trade sale, this is an extremely lengthy document. I mean, normally they in excess of 100 pages, and it's very heavily negotiated, and that process can take quite a while. MBOs, there is still a very lengthy SPA negotiated, because there will still be lots of warranted things in there. As far as EOTs are concerned, it's certainly more light touch, because of the involvement probably that the sellers will still have in the business once completion's taken place. So if we look at sort of various aspects of the SPA, the parts which are probably the most heavily negotiated relate to warranties, indemnities, and a tax covenant. Warranties, basically contractual promises that as a seller you are selling what you say you're selling. Two main purposes for warranties as far as a buyer is concerned. One, it gives them a contractual remedy for damages if it turns out any of these warranties are untrue, and also it makes it it forces the sellers to actually provide as much information as they can to the buyers, which they might not always necessarily want to provide, but if they don't provide it, it could actually lead to a breach of warranty claim. And so it's it's useful from that perspective. The warranties in a trade sale will be extensive. They will cover the same part in the same way as the DD side. They will cover everything, every single aspect of the business, and they will be very heavily negotiated. Lawyers get very sort of paranoid about negotiating warranties. To be fair, provided that you've been very open during the due diligence process and you have basically told your buyer everything they need to know, and then coupled with that, you've basically repeated that process as part of your disclosures, which I'll come on to in a sec. It's quite rare normally for there to be warranty claims brought, but it does depend on how transparent and open you are at the DD stage and then the disclosure stage. Less warranties in an MBO, again because of the fact that the MBO team probably will have should have detailed knowledge of the business already. Things like pensions, accounts, tax, maybe property are where there is still quite a bit of negotiation on the warranties. And as far as an EOT is concerned, you might be required to give warranties of title so that you own the shares, but that's kind of it. Indemnities, they're more onerous than warranties. They're significantly more onerous. And as a lawyer, we try and, we certainly, our starting point is don't give indemnities. Indemnities basically are to cover certain specific risks that a buyer identifies. And if a claim is brought against you under an indemnity, then basically you're liable on a pound-for-pound basis for any losses which the buyer has suffered. And I mean, examples of things which buyers commonly require to be indemnified are environmental risks, product liability claims, infringement of intellectual property or potential infringement of intellectual property. Indemnities, very, very common in trade sales. There may be some in an MBO, but again, it depends just how much knowledge the MBO team have got. It's rare, if almost unlikely, that you would ever be required to indemnify anything in an EOT. Tax covenants are a form of indemnity. Basically, sellers are agreeing to indemnify the buyers against any tax liabilities which have arisen up to the point of completion. Tax covenants are required in all three sets of transactions normally. Another area, another issue which basically is found in an SPA in all three types of deal restrictive covenants, basically for a period of time which might be normally between 1 and 3 years. It might be a bit longer, although you need to bear in mind if you're a purchaser that the longer restrictive covenants last, the less enforceable they become. But basically, for a period of time, as a seller, you are agreeing that you won't get involved in any other business which is in competition with the target. You agree not to tap up the suppliers, the customers, the staff, and it may be the case that you're also required to give additional covenants which will prevent you from using the name of the target or basically saying anything defamatory about the business that you've just sold. And I say these basically cover all three types of deal. Security is an important aspect on all three types of deal, particularly if it's a case that some of the purchase price is going to be on a deferred basis. Then it's very important as a seller that you have a conversation very early on in the process to find out what security the purchaser will give you for that deferred element. So it might be a charge over the assets of the company, although, albeit, as David said, the bank, if there is bank lending, they will always make sure that their charge ranks first. But you need to find out what security you've got. It may be the case it's a corporate guarantee. It might even be personal guarantees from directors of the buying company. But security is important, and it applies if there's a deferred element in all three types of transaction. The only thing, as I've mentioned in the slide, is that on an EOT you can't be given, or you can't provide security. Security can't be given over the shares of the company. Right, other things that we deal with, sort of seller protections. Again, sort of focusing on the deferred. If there is a deferred element of the consideration, it's a good idea as a seller to insist that if, for example, that payments have been made over 2 years on a monthly or a quarterly basis, that if a buyer misses, let's say, one or maybe two together payments, then that's a trigger for the balance becoming outstanding or becoming paid immediately, and it keeps the buyer very focused if you have that type of provision in the agreement. If the part of the consideration is based on an earn-out, so it basically means that the target has to achieve certain financial targets, milestones before part of the consideration is paid. Then from a seller's perspective, it's very important that you put protections in place to make sure that the buyer doesn't start doing things which could have the effect of distorting the financial performance of the target. So you don't want the buyer to be able to divert business opportunities away or divert staff away to another part of the group, or allow them to impose onerous management charges, things like that. So we put in protections to sort of how the business might be run during that during the earn-out period. If you're retaining a minority shareholding in the company, then it's recommended that there's a separate shareholders agreement entered into, which would give you as a minority shareholder protection in terms of how important decisions are made and whether you can have any say in that, whether you can be appointed director, or how dividends are going to get paid. So it's important to have a shareholders agreement in place if you are a minority shareholder in staying in the business. In an EOT situation, it's quite common, unless all the purchase price is going to be paid in one go, it's very common to see the purchase price being paid on a deferred basis over quite a long period of time, maybe 5, 6, 7 years perhaps. So it's equally common to have what we call, as lawyers call, an anti-embarrassment clause in the agreement, which basically says that once the business has been sold, if then the buyer sells the business themselves within a specified period of time, which might normally be between 6 months, 2 years post-completion, then if the buyer's sale actually is for a price which is higher than what they bought the business for themselves, then the original seller will get a percentage of that uplift. Okay, so as I said earlier, warranties, indemnities, tax covenants, they are some of the most sort of heavily negotiated parts of any deal. And one of the best ways to protect you as a seller is to ensure that if there are any exceptions to any of the warranties that you're providing, that you disclose those exceptions in what we call a disclosure letter, which is provided to the buyer at completion. The disclosure process, I'm afraid, can be quite painful for both the lawyer and for you as the seller, because we have to go through every single warranty one by one and analyse whether a disclosure needs to be made. It's a long process. It can take a lot of time. It's important from your perspective, you're selling, that that you have everybody available during that meeting, particularly with the lawyer, who has any knowledge of the business. So you need to get your senior management people in so that between you, you can provide all the information that we need to make full disclosures against warranties. Because as I say, if you don't make full disclosures, it could lead to a breach of warranty claim. That disclosure letter is basically something that's provided, particularly, definitely in trade sales, MBOs, depending on the level of warranties. If they're just title warranties being provided in an EOT, then you may take a view and decide that a disclosure letter is not necessary. Limitation of liability clauses, again, are something from a seller's perspective which are heavily negotiated, are very, very important. Things like your maximum liability will be no more than the purchase price you receive. Absolutely critical. You don't want to have to be potentially liable to pay back more than you actually got in the first place. Things like ensuring that the warranty, the time for bringing a warranty claim, the time for bringing an indemnity claim should be a fixed period of time. So, and it varies, but normally it's between 1 and 2 years that the buyer has to bring claims, after which they are then stopped from bringing claims. That's for general warranty claims. Tax warranty claims, tax covenant claims, it's longer period, normally 7 years. We also try and dilute the warranties as much as we can. For example, there might be a warranty which says the company has at all times complied with all relevant laws. Now, we can try and dilute that by saying, as far as the sellers are aware, there's been compliance with all laws, or there's been compliance in all material respects. It's diluting the effect, which is great from seller's perspective. Buyers don't like it, and there's always part of this negotiation there. And then finally, we have what we call the ancillary documents to negotiate and agree. So, I mean, as part of any deal, it's likely that the current directors will have to resign, and new directors have to be appointed. Registered office might be changed, accountants might be changed, the accounting date might change. So we need board minutes to basically record all that. If you are resigning as a director, you will probably be required to sign something which basically says that you will not bring any claim against the target arising from your resignation as a director. If you're an employee, you may be required to sign a settlement agreement, which basically is a document which essentially says that in return for the money you're getting for your shares, you agree to give up any employment rights that you have in terms of bringing any type of claim, any employment-related claim against the company. Sort of linked to that, there's also a separate document you're normally required to sign, which says that if you have any other types of claim against the company, or anybody connected to you has any claims against the company, then either they don't exist or you waive those claims as at date of completion. And then obviously little things like stock transfer forms. Obviously there's the piece of paper that actually transfers the shares from seller to buyer. And then finally, if there is any existing security in place over the target, existing debentures, then buyer will normally require those to be released either in full or at least a partial release before completion can take place. So you'll need to have conversations with your bank to find out what they need to basically agree to release that security and get those release documents agreed as well. Okay, that's it.